Hi, good morning everyone. Welcome to the third webinar in the webinar series for working with children and youth with complex mental health needs, an integrated training project. Today's webinar is called Navigating the Youth Criminal Justice and Mental Health Systems, and I'm Renee Ferguson. I'm going to be your moderator for today. Today's webinar is going to offer an overview of legislation and justice-related terminology that impacts some of the already complex issues that some of your youth service users are struggling with. What I'd like us to do is just take a quick poll to find out who's been with us for the last few webinars. So you can see the poll on your screen now. So if you were with us for webinar 1 and webinar 2, you can click the first two, or if you were with us for both. And then if this is your first webinar, which it looks like a number of people, it's their first time, welcome. So it looks like we have a pretty good split between people who it's their first time with us and people who were here for both 1 and 2. So for people who were with us, who are just joining us for the first time, I would really encourage you to check out the first webinar, which gives a really good introduction to what the project is, as well as what we're talking about when we're talking about complex mental health needs, which is really the focus for the entire training. I'll speak a little bit about it today, but if you want more information, I really encourage you to check out the previous webinars, especially the first one, and you can find that on www.complexneeds.ca. Okay. So a quick description of our project. So this is a project that's designed to offer some foundation training for direct service providers in Ontario who are working with children and youth with complex mental health needs. And in a little bit, I'll talk about what we mean when we use the term complex mental health needs. So it's really focusing on this particular group, and there are 4 areas to this project. You're participating in one area. The first is a live inventory comprising of training that's already available in Ontario. So currently we have about 65 trainings that are going on in Ontario. We've listed them on the website, www.complexneeds.ca. And you can do a search, so you can look at trainings that you're specifically interested. We call it living because if there's a training that you are doing in your organization and you want people to know about it, you can actually submit the training directly to the inventory and then we'll post it. The other is a series of webinars. So this is the third in the series of webinars that we're presenting. They're mostly focused on social determinants of health. So if you kind of look through the website, you can see the variety of topics. So the first one was an introduction to complex mental health needs. And then 2 weeks ago, we had one on adopting a health equity approach to this particular population. And then the third is a 2-day training, so the face-to-face training that's happening in 4 areas of the province. So Toronto, Thunder Bay happened on October 8th and 9th. Ottawa is coming up in 2 weeks, and then London is the one that we're finishing with. And the focus of those face-to-face trainings are how do you work with children in complex mental health needs using a trauma-informed lens. And the last piece is a 6-part online course that focuses on providing brief services, and that will be available in January. So for more information, detailed information on these pieces of the training, I encourage you to check out the website. Again, www.complexneeds.ca. So today's webinar, we have a collaboration between CMHA Ontario and CAMH. Once again, as has happened in the last 2 weeks, we're lucky to have 2 very solid presenters. Tanya Breton is joining us from CAMH, where she's the Regional Implementation Coordinator for the Champlain Youth Justice Collaborative, East Region Office at the Centre for Addiction and Mental Health. And then we have our colleague, Dorina Simeonov, who's at CMHA here in Ontario, and she's actually focused on point you to. The first definition is what do we mean by youth? for this particular project. So we're looking at youth as meaning anyone between the ages of 0 and 29, and really thinking about those transitional youth experiences. And the second piece is, what do we mean when we talk about complex mental health needs? So we're looking at children and youth who are experiencing significant, multiple, rare, or persistent mental health challenges that impacts their functioning in most areas. And I'll show you an example in a little bit, such as home, school, and community. So some examples of this, and they're not limited to, so children and youth living with co-occurring disorders with multiple diagnoses, and then children and youth who are living with disorders that are impacted by things like social exclusion, involvement with the justice system, as we'll speak about today, or children and youth who are coming from histories of trauma. So for example, when we're thinking about all of these systems that they may be involved in, I'm going to point you to this diagram on your screen. And you're thinking about a 16-year-old youth who has Williams syndrome, but who's also living with depression. And his family's just living above the poverty line, and also lives 2 hours away from an urban hub. So there's a bunch of things that could be happening. So you have home involvement, which maybe the family's asking, how can I manage financial resources for my son while being on a fixed income, which is a very real experience. The school may be asking questions like, are we even doing enough? How do we support students with, this particular student with community life, this transition from school to work? And then the medical doctor might be asking, well, what kinds of mental health supports are available for this young person who's living so far away from an urban hub where there may be more resources? So there you can see involvement in a number of systems and how not only involvement, but the kind of level of involvement that these systems may have. So this is what we're really talking about when we're talking about complex mental health needs. So again, for more information, and I'll put this up at the end again, check out our website. This is where you can register for future trainings, you can ask questions, you can check out news pieces. And on that note, I'm going to invite Dorina back again to start us off with the youth criminal justice mental health system. Welcome, Dorina.
Thanks
for being here.
All right, so before we start our talk, I just want to note that we're doing a bit of a different presentation. We're using a Prezi, and it's more of a dynamic presentation. So if you're noticing that maybe the presentation is lagging a bit, connection, but we are going to go very slowly through the slides, and at the bottom there, they are available in French and English, and these were created in collaboration with CMHA. We also have adult justice maps that you can find on our CMHA Ontario website. So as Renee mentioned, I'm Dorina Semyonov. I'm a policy analyst here, really looking at the intersection between the criminal justice and mental health systems. We look at other issues as well all across the justice system, so police interactions with individuals who are experiencing a mental health crisis, as well as topics like police record checks and mental health courts. And I have my co-presenter with me as well, Tanya Breton.
Good morning, everyone. We're on the cusp of morning and afternoon, so I guess we'll get to transition through that one together. As introduced, my name is Tanya Breton. I'm the Regional Implementation Coordinator with the Provincial System Support Program at CAMH. Champlain is the Youth Justice Service Collaborative. It is one of 18 different service collaboratives. And I guess our primary focus is looking at systems improvement through service collaboratives.
Great. So we wanted to get things started by asking you a question. And while you answer that question, it's an open-ended question. What is the first thing that you think of when, what comes to mind when you think of the justice system? And while you answer that, I'll just share our Prezi with you. So feel free to fill that in. So I see some folks think of mental health, confusion. Well, hopefully we can clear up some of that confusion today. It's very complicated. I see complicated coming up twice. It's a very slow process.
Trauma.
Yeah. Scary and complicated, yeah.
We don't have anything until next week.
So,
How is
so hopefully with this webinar we can address some of these issues. I mean, you can see that it's a great concern, and as you can imagine for youth with mental health issues going through the justice system, it can be traumatic. It can be extremely unfamiliar, especially if that youth doesn't have the supports that they need. So just to lighten that mood, when I think of youth justice, I think of Young Justice, which is the youth version of the Justice League for all of you comic book fans out there. But as you know, our childhood heroes may have taught us right from wrong, but things aren't so simple in the real world, and definitely not for our youth. So you can see this is kind of a big overview of our Prezi today. We're going to break down that map that you hopefully have in front of you. This is what it looks like all together. This is the big picture of that map. And we encourage you to follow along, especially, some people say they get motion sickness when they watch Prezi, so feel free to just look at your map.
So are you familiar with the...
So we're going to do the next poll now, and we'd like to hear a little bit more about you, now that we've introduced ourselves, and ask you what sector are you from?
We have a third presenter on the line with us.
I think they're gone. Right. So Tanya, given our poll here, could you just comment briefly on just complex needs and how that relates to the justice system?
Well, I think that with complex needs, it's an interesting aspect because with youth justice, we're seeing more and more kids with mental health, addiction, and developmental issues coming to interface with the justice system. And, there's recently a stat from the Canadian Academy of Child Psychiatry that indicates that there's a child psychiatrist, 1 per 4,305 children and youth. So that seems to be a big challenge around resources and providing the unique support that's necessary. But I think that, it's very important that we address those concerns and make sure that we can support them through those navigation of services.
Great. So the aim of this map is really it's not only for service providers, but it's also for youth and their families to give them a better sense of all the possible pathways that you can go through. It's not a one-size-fits-all, as you know. The justice system can be very complicated, and there's all sorts of avenues that one can go through. Tanya, I know you used this map with the Champlain Service Collaborative.
So when we started off with these service collaboratives, we asked 6 ministries to kind of guide us in creating a good decision tool. I mean, mapping out the criminal justice system is a complicated process, and they came up with this map, which is kind of a snapshot, and we kind of presented it to our community partners so that it could guide us through those conversations about what are some key transition gaps or service gaps that the communities wish to target. And when you kind of break up the navigation aspect into kind of 8 different junctures, it allows that more in-depth conversation about how we can start targeting those gaps. So Champlain utilized this map to help kind of corner what we wanted to work on from a system service change.
Great. So let's move right along. So we're going to go right into our presentation. As Renee mentioned, we're going to cover some legislation just right off the bat. And then we're going to look at some of the pathways. And please note, we will have that question and answer period at the end of the presentation, but we're also going to stop halfway through because, as many of you said, it can be a really confusing topic. So we're going to take a pause about midway and see if you've got any questions at that point as well. All right. So important legislation. There are 2 types of systems in Canada: the forensic mental health system, which is governed by the Criminal Code of Canada at the federal level, and the civil mental health system, which is governed by various legislation at the provincial level, and we're going to go into depth. But before we do that, as Renee mentioned, when we look at youth in this project, we're talking about youth under 29. However, when we look at the legislation, it's a little bit different, and Tanya's going to speak to that a little bit more.
So when we look at the Youth Criminal Justice Act, 'cause that's our focus today, the Youth Criminal Justice Act indicates that, a child is younger than 12, a young person is 12 to 16, and an adult is 18. So today our primary focus will be on the 12 to 17 less a day, and that's the target of our conversation.
And we'd like to just ask you which populations you might work with, if you're working with children and youth and adults as well in your work. We'd love to hear which population you're working with specifically. So that's perfect. A lot of you are right in that category that we're going to be speaking about today, the 12 to 17. So we're going to move right along, and we're going to talk about the forensic mental health system at the federal level. So this system is based on the Criminal Code of Canada, and specifically Part 20.1, Section 672, and it really outlines the criminal justice process for mentally disordered accused. And when we talk about that, it might not be language that most of us use in the community mental health and addiction sector. So we're going to just break it down a little bit for you. So when we talk about a mental disorder, the criminal code really defines that as a disease of the mind. And it's a really broad definition when we talk about the criminal code. It doesn't differentiate between a mental illness, addiction, developmental disability, or acquired brain injury. It can encompass all of those things. And a mentally disordered accused is an individual with a mental disorder under that definition who has been accused of committing a crime under the criminal code, and that includes those who are deemed unfit to stand trial and those that are rendered a verdict of not criminally responsible. And I'm going to explain to you what those terms mean a little bit later on when we get to that part of the map. A mentally disordered offender, on the other hand, is an individual with a mental disorder that has been determined by a court to be guilty of an offense. So this can happen in two ways, either by the acceptance of a guilty plea from the individual or by a finding of guilt. So again, if you hear me using the word mental disorder throughout the presentation, I am referring to that criminal code definition, so it's a bit broader than just mental health. Tanya's going to walk you through the next two definitions.
So I think it's very important to note that there's a lot of discrepancies about what is a forensic patient and what is a forensic client. So a forensic patient is an individual who has been referred by the courts for assessment or have been declared NCR or unfit by the criminal justice system and are currently admitted to the provincial forensic mental health system. In Ontario, the forensic patients are under the jurisdiction of the ORB status. So forensic clients to be a very specific population. So this includes individuals with major mental disorders who are in conflict with the law and are being dealt with by the courts or the Ontario Review Board under Section 672 of the Criminal Code. This would include those who are unfit to stand trial, those with verdict of not criminally responsible due to mental health disorder. And I think it's very clear to indicate that, having youth under the Ontario Review Board is very rare in the Youth Criminal Justice Act system, and that we actually currently only have 6 active files under 18 across Ontario right now.
Great.
So I guess we're moving forward to the next section, which is the Youth Criminal Justice Act. So the Youth Criminal Justice Act does aim to reduce the use of formal systems for youth with the opportunity of particularly looking at non-violent offenses. So one of the clear declaration of principles is to prevent crime by addressing circumstances of underlying youth persons' offending behavior. So it's really targeting those underlying presenting situations or issues that you can target. as well as rehabilitating young persons who commit offenses and reintegrate them back into their society or community, as well as ensuring that young persons are subject to meaningful consequences for their offenses, for those who have done an indictable offense or there is harm to those in the community and victims. Some of the Youth Criminal Justice Act does have some mental health assessments currently under the Act. I mean, with each community we tend to get creative, but under legislation there is a stipulation of having a Section 34, which allows the Youth Justice Court to, at any stage, order a young person to be assessed by a qualified person. It could be a forensic psychologist, could be a psychiatrist, depends on the community that currently has a service contract from MCYS, and who's required to report the results in writing to court. The order is made when a court has reasonable grounds to believe that the young person is suffering from a physical or mental illness or disorder, a psychological disorder, an emotional disturbance, a learning disability, and a mental disability. And they need to have a history of repeat offense and or the young person is alleged to have committed a serious offense. I know that many justices tend to get a little creative around a Section 34, seeing that it tends to be the key access in getting an assessment in the criminal justice process. But there are other forms of assessments and screenings in justice systems that different communities tend to practice. So, for example, in a community setting, you can always tap into family physicians, police diversion. So for police diversion, many actually use the YLS CMI screening tool. Pre-trial detention, the youth mental health court worker who does pre and post, some are trained with MAZE, CANS, CAFIS, as well as in custody. So for those youth that actually are held and detained, youth mental health court work conducts assessments, the Section 34 at any time, and even probation services if there's an order for a pre-sentence report. They themselves are doing community assessments as well that can really guide and provide information to the court. And custody facilities have their own external contracts with practitioners in the community that can help support those youth with complex needs.
So that kind of covers the forensic side of things. And now we're going to go into the civil mental health system, and Tanya is going to continue on with the Child and Family Services Act.
So the Child Family Services Act is a legislation to which its main goal is for the child protection, to ensure that the rights and apprehension, secure treatment options, you can place a youth in secure treatment for 180 days and or 30 days for emergency cases, or youth justice, where the legislation that parallels well with the Youth Criminal Justice Act. The Act focuses on the management of custody, detention and supervision programs resulting from laying of the charges, and sentencing administered by a youth justice court. I think it's very important to know that there's currently 2 secure treatment facilities in Ontario, one being the Robert Smart Centre in the Ottawa area, East Region, as well as the LAPS Youth Centre in Oakville. There are other per diem mental health beds to which CES or child welfare agencies can place youth in. I think it's an avenue that is intrusive and takes a lot of legislation and criteria under the CFSA to access, but it is an excellent resource for those youth with complex needs.
Great. So I'm going to speak to the rest of the provincial legislative pieces. So there's 3 more. The first one is the Ontario Mental Health Act. And Section 17 of this act is the piece of legislation that permits police officers to apprehend individuals whose behavior appears to be a danger to themselves or others. So there's some key words in the Act that say a police officer can apprehend an individual if they have reasonable and probable grounds to believe that the person is acting in a disorderly manner and believe the person is a harm to themselves, to others, or is unable to take care of him or herself. So in other words, officers that believe an individual is suffering from, again, a mental disorder and is at risk of harming themselves or others, they can go ahead and apprehend that individual, and we call that a Mental Health Act apprehension. And let's just pause and think about that for a second. I mean, having a mental illness is really the only illness that can lead to this type of contact with police. You wouldn't be detained by police, for example, for showing symptoms of diabetes or heart disease, but you can be detained for showing symptoms of a mental illness. So once an apprehension is made, a police officer has the legal duty to remain and retain custody of that individual until the hospital has accepted custody themselves. So once the examination by the physician takes place, Section 20 of the Mental Health Act comes into play, and the physician can then release that individual, or they can admit the individual to hospital as an involuntary or voluntary patient. So now we're going to talk about Ontario's Healthcare Consent Act, and just zoom in there. So this act states that an individual has the right to refuse treatment, and that treatment may not be administered unless consented to by the individual or their substitute decision maker. So again, under Section 20 of the Mental Health Act, the physician can authorize an involuntary admission if that person is incapable of consenting to his or her treatment, or that person's substitute decision maker has given consent. So when we talk about youth, this can be a parent or a guardian. So let's look at the last one here. It's the Personal Health Information and Protection Act, or PHIPA. So this states that only a health information custodian can have custody or control of personal health information, and that's as a result of or in connection with performing that person or an organization's power or duties. So under this act and under Section 20 of this particular piece of legislation, healthcare providers can disclose mental health information, but only if the client has given consent, or if that disclosure is absolutely necessary to eliminate or reduce a significant risk or serious bodily harm to individuals or the community. So what's interesting about this piece of legislation is that police officers, correctional officers, and many other justice professionals are not health information custodians. And this can raise a lot of issues with regards to sharing information about clients that may be really important in getting them the appropriate care. And it can lead to a lot of difficulties in communicating across the sectors.
Thank you, Joanna. That covers a lot of important legislation, and I think it's important to have those foundational information shared, just so that people have an overall history of all the other competing legislations that we have to keep in mind. So let's move forward to the map. So for those that want to actually open their attachment of that map, they can follow through, or they can continue with Prezi with us. So the first step in the map, we want to look at a typical journey about what it looks like to walk through the justice system. So here at step one, I think it's very important to comment about the supports. I think that as care providers and community partners, I think it's very important to note that it's very important to have those formal supports in place, so family members, extended family, people that have a meaningful impact on youth and children. We do have a lot of informal supports that are currently embedded in the system, but I think that having those supports in place really leads to the success of the youth going through the justice system.
All right. An encounter between police and a youth, in this case, with a mental disorder. So police officer often are the first ones on a scene of an emergency, and municipal and provincial police may be called upon to respond as a result of a disturbance call or a call regarding unusual behavior or an identified mental health crisis call. And this includes those what are sometimes referred to as emotionally disturbed person calls, and that's police terminology for those calls. And in these cases, in all of these cases, it would be an event where a youth is having a mental health issue and is in some sort of crisis. And so from this step, we can, when we go, so anytime we go up on this diagram, we're going into the justice system, and when we go down, we're going into the mental health system. So we're going to go just up to extrajudicial measures now.
So as Doreen indicated, this is kind of our first step where you have that kind of justice involvement, you're having police contact. So with the extrajudicial, it's where youth can receive a different form of support through community-based agencies. The aim is to hold the persons accountable without proceeding through formal court systems. So extrajudicial means outside. So you really aim not to have formal proceedings, but more from an externalized community support method to make sure that the needs of the youth are being addressed. It can be used for persons who are being dealt with by, extrajudicial measures or have been previously found guilty of an offense. When responding to the youth offending behavior, police are encouraged to use extrajudicial sanctions and measures. Examples that you can utilize are caution, warning, referral to formalized diversion programs, referral to community services. Even in many communities, we have officers that, EGM programs are getting more and more referrals, and they're becoming more valuable under the Youth Criminal Justice Act. And recent stats from the CCGS is that the EGM programs from 2006 actually went from 14 operational programs to 43 in 2013, and that even includes 9 original specific EGM programs. So I think that the stats kind of indicate the benefit of looking outside the court system for many youth.
All right, so that covers some of the extrajudicial measures, and so those are outside of the court. So now I'm going to talk about, we're going to go down a little bit to pre-charge diversion. So youth can also be diverted away from the justice system at this initial stage, depending on the severity of the offense. And if that youth is known to police, they may have come into contact with police before. If there's a risk of harm to that individual or someone else or the community more broadly, police, depending on the case, may take no further action. They may involve parents, give an informal or formal warning. Again, send that individual to a pre-charge diversion program where they can receive some services. They can be apprehended under the Mental Health Act, as we described earlier. At that initial point of contact, once the scene is secure in a mental health crisis situation, those first responder police officers can call upon specially trained intervention teams, so things like the mobile crisis intervention teams that we have in Toronto, or the crisis outreach and support teams that are present in areas like Hamilton and Halton region. They can also refer that youth to a crisis bed or a safe bed, and these are really alternatives to custody or having that youth sent to the emergency room. Typically, an individual would remain in a crisis bed setting for a short period of time while linkages are being made and referrals to other community programs.
So now that we've explored EGM and EGS as options to keep charges outside the court system, we're going to move into the next phase of the steps, is where there could be potential arrest and charge. For those that are actually looking at arrest and charge, usually the police have to review whether there's public safety concerns, that need to be addressed on the scene, given the date for their first court appearance, released. Otherwise, the individual is taken to courthouse where a justice of the peace can order a detention order or detain until the bail hearing or first court appearance will occur. I think it's very important that those kind of factors are based on the seriousness of offense, the individual is known to police, or if there's a risk of harm to individuals, someone, or the community. If any public safety concerns can be addressed at the scene of the individual, they can basically be given a date and get a reconnaissance or a notice to appear where they can remain in the community. These reasons to detain a youth could be for reasonable grounds that the youth will not appear in court. Maybe there's a history where they won't appear in court. The need to secure or preserve the evidence. The need to prevent another offense from occurring. And if the accused is not released on bail by a justice of the peace, they can have a new bail hearing in front of a judge. And if they also fail to get a bail from that judge, then just like adults, they can go higher court for a review of decision.
All right, so you can see how at this beginning part of the map, you can see how a police officer's knowledge base can really determine whether an individual is going to be referred to a pre-charge diversion program, and that's really, in some of these cases where the youth has a severe mental health issue, that's really what we would want. It lessens the criminalization of individuals experiencing a mental health or addictions issue and provides that linkage to some of the mental health and social services available in that person's community. And that's why really police education and training is extremely important and can determine how one moves through this system.
I think another added comment to that too is that many police services work in collaboration with community partners to assist, especially with those multifaceted cases. So I think that having police continue to collaborate on top of the training aspect is a key thing as well. So moving forward, the next step in the map is the bail hearing. In the community, at this step in number 3, we have a bail hearing where an individual can be released until the first court appearance. In the community, you can see, I'm actually going to get Doreen to click one more time to bring us maybe a little bit closer. Here, I'll just do that. Sorry. My old eyes doesn't allow me to see that small writing.
All right. And just a note on that, I know some folks, this is a much more detailed version of the map. We've added a lot of notes here and there through the Prezi, and we are going to make the Prezi link available as well, so you can refer back to the Prezi just as you would to a slide deck as well.
Thank you, Dorina. Now my old eyes can see things. So with the bail hearing in the community, kind of a generalized overview of it is they would appear in remand court, which is an administrative court. The youth lawyer will go on record. They place their name on the file. A lawyer will be appointed and or legal aid will be picked up for the youth's file. The lawyer will request for a disclosure, the facts of the file, so they can review their options with the youth and family. And the youth's file to be adjourned to another remand court in order to plan around next steps. So this is kind of like that planning phase where the family and youth are first having their contact with their lawyer, and it's an opportunity to kind of look at the facts and decide whether or not there's a guilty plea, a not guilty plea, and see whether or not they meet the criteria to look at extrajudicial sanctions or going to trial. The other option for those, as indicated previously, where police did detain them and they're currently in custody, they can appear in person. You have a choice. You either can have it via video remand, which is a camera video linked from detention centers, or you can have the young person be transported from the detention center in person for their remand hearing. Their lawyer will go on record, very similar from the community aspect, make sure that they're on the youth file. A lawyer will be appointed. The lawyer will request a disclosure, yet again, very similar from the community aspect. And the youth file will be adjourned to another remand court date in order to plan around next steps. This is where it's going to differ a bit from a community perspective because the complexity of being in detention means that there might be other aggravating factors, or there might be an opportunity to which you actually have to create a more comprehensive plan for release. So I think it's very important that, if there's a request for bail hearing, they do have 24 hours after the arrest. And also, they may need to have a more comprehensive conversation with the Crown, and that would be a counsel pretrial, or if for some reason they need to bring a judge to hear the facts, a judicial pretrial under Section 536.3 of the Criminal Justice Act. On to you, Dorina.
All right. So at this stage, the youth can also be sent to a detention center, and detention is justified only if deemed necessary on some of the following grounds. So to ensure that that youth is going to attend the court, so if they have a history of failing to attend court or abide by the court orders that they've been given, they might be placed in a detention center to protect the public. So if the youth has a criminal record for similar offenses, and to maintain confidence in the administration of justice. So the court will consider the apparent strength of the prosecution's case, the gravity of the offense, and the circumstances surrounding its commission, and just the potential for a lengthy jail term, and then they'll decide whether that youth goes into detention.
I think that we should also note, Dorina, that one of the key principles under the Youth Criminal Justice Act is that detention is not to be used as a substitute for appropriate child protection, mental health, or other social measures. So that's Section 29, Bracket 1. That seems to be a principle that tends to be brought up on a regular basis, especially with our complex needs kids, seeing that oftentimes they're held in detention longer because the need to do more planning around treatment goals.
Great, so that covers step 3, and we're going to go right into step 4. And that's you, Tanya.
Thank you, Dorina. So as mentioned before, we did do a kind of quick overview of extrajudicial measures. Its sister partner is extrajudicial sanctions. Anytime the word sanctions is indicated when you actually are involving the Crown and the court process to make sure it's being moderated and that there are measures to be evaluated so that the Crown can get an update. So this is more of a second stage. So for those that may have used EGM on other matters and they re-incurred a new charge, it could be an escalation where police, lawyers, and Crowns may look at EGS as the next step. Or it could be the first entry due to the charges or what are the current presenting factors. But I think with extrajudicial sanctions, it is a community-based again, and should be used only where a young person cannot adequately dealt with by the way of warning, caution, or referral. It's a little bit more formalized where they would meet with an individual in a community partner, especially those that actually have a servicing contract with MCYS. You know, there's apology to victim, community service work, restitution, cognitive behavioral skills, anger management, life skills, substance abuse, counseling and treatment. And I think from previous experience, there's even some community partners that actually have externalized contracts with psychiatrists who could do a quick triage or recommendation around treatment goals.
All right. So if we go down from that first court appearance, after charges have been laid, the Youth Justice Court also has the option to divert youth into the appropriate treatment and support into the community. And they can also refer them to a youth mental health court worker, and as Tanya mentioned, impose some of those extrajudicial sanctions. So I'm just going to briefly talk about the role of youth mental health court workers, and their role is really to meet youth sometimes in the holding cells, to make those referrals to the appropriate agencies and really advocate for youth and their families. They implement bail plans, and they also propose mental health diversion to the Crown and discuss that plan. So here's the piece that I mentioned at the beginning that I would talk about around fitness to stand trial. So at any time in the court process, the issue of fitness can be raised under the Criminal Code Section 672. And a person is found unfit to stand trial if they have a mental disorder that prevents them from understanding the nature of what happens in court and the possible consequences of what happens as well. Or if they have trouble communicating with and instructing their lawyer. If the person is found unfit, the judge may issue a make-fit order or treatment order for the accused to receive treatment in a psychiatric facilities for up to 60 days. And this is rare in use, and Tanya is going to elaborate on that a little bit.
I think this is when that at times legislation competes with other legislations. They sometimes don't correlate or align well. With the Youth Criminal Justice Act, many youth that are in the court system with mental health disorders, there's currently no formalized youth forensic beds in Ontario. It's a very rare program to which you could do a direct inpatient action under the Mental Health Act. So a lot of communities have taken on a more creative approach in kind of merging or aligning that gap. And I know that in Ottawa here we had used a young file where we actually had them released on reconnaissance and then actually were able to place them in an inpatient bed with youth psychiatry where we had an assessment completed and then had them attend court with support of the court workers. So I think that the community tends to be very creative with our complex needs, especially when there is a gap in legislation and other supportive tools in the community. But I think that usually we do our best as community partners and systems to try to make sure that the youth are being protected and supported.
Great. So that covers step 4. And because we're about halfway through the map, we're going to just pause now and take some of your questions because it is a pretty complex topic. So if there's something that you have burning, you're just wondering if you're confused about a particular aspect of what we've told you so far, please go ahead and type your questions in the chat box there.
Just giving it a few minutes for people to get their questions in. We can see that people are typing, but the questions aren't posted yet. So just a few minutes. There might be a bit of silence. Okay. First question. Does law enforcement get training on this, and to what extent?
I can take that question, Dorina. I think that in a lot of local areas, they have a lot of collaborative initiatives such as LEAD training, which is a first encounter mental health providers where they actually do training modules around the mental health programs, best pathways for first responders and police officers. But again, I think that's really based on a regional sense.
Yeah. And so I'm just kind of looking through some of the questions, some of the technical pieces. We'll try to speak as clearly and as closely to the mics as possible so that you can hear us. And for those of you looking for the maps, the links are up again on the bottom right of your screen. There's a French version and an English version. They can also be found on the CMHA Ontario website as well. So you can maybe take the next question. Why is it rare for youth to be found unfit? Maybe we can explain that a little bit better.
I don't think it's a rare to be found unfit. I think that when we're talking with youth and you look at the legislation, if you find someone unfit and then the next step is NCR, it's almost more onerous to enter them into the NCR system than it is to keep them remained in the youth justice system. For example, if a youth committed a crime and they were, they did a Section 34, there was a mental health assessment, great programs to connect with the youth, putting them on a period of probation, they would have no longer than a term of 24 months. However, if you were to found unfit and they entered the NCR system, then they're looking at a more complex system where there is no clear end date for youth.
Great. So I'm going to take the next one, which kind of relates to the first question. Do police get standardized training on the Mental Health Act and diversion? The training around mental health in general and the diversion, there's different diversion programs across Ontario. The training across Ontario for police officers also varies. Some municipal police services have really specific training on mental health. They might have extra training because they feel they need it. If you're interested in that piece, there is a recent report by the Mental Health Commission of Canada called the Tempo Report that really outlines and proposes a standard for police mental health training. So I encourage you to check that out. And we can certainly send that out in our follow-up. We can send a link to that. One question is, are there bail hearings on weekends?
Unfortunately, there is. I know that some lawyers do get calls throughout the weekend, as well as justices of the peace may have to sit on a weekend. I don't think they do very comprehensive bail hearings. It may be more or less a determination of whether or not they need to remain in detention or whether they can be released on reconnaissance. Most bail hearings are held during the week where you have a full complement and an opportunity to review all the information from police.
And the next one I think is probably for you as well. What kind of support is there for family while youth are in the detention center?
I think that the ministry has really dedicated a lot of supports and resources to this. I think that having someone in detention or custody is the most intrusive environment. And I can only speak to what is currently here in the Ottawa area or Champlain, but I know that in our local detention and custody, we have an array of supportive programs, including a community justice team where you have the youth mental health court worker, anger management. We even have a one-to-one counselors. We have a clinical coordinator. We even have a contracted forensic psychiatrist. On top of that, all the staff are trained on ongoing best practices on how to support these complex needs. I have to mention that many of these detention centers in custody work very closely with the school boards, and they ensure that they continue on those progressions to get the credits and make them feel empowered. I know that even some of the local detention centers are looking at skill trades and making sure that youth can walk away from detention in custody with skills such as welding so that they're actually entering workforce if they're on the cusp of their 18 years. And I can go further and further, but I really think that this is actually an area where there's a lot of supportive pieces for the youth and family, but it's just making sure that there's open communication and that the family actually remain engaged in that process.
Great. So I'm seeing a lot of questions, but I want to make sure that we finish off our map. So we will come back to some of your questions at the end. And please note that link, if it's not working for you, the Prezi link, we will send it out at the end of the presentation as well.
Wow, great question, guys. And I hope, I tend to go very verbal diarrhea at times, so please let me know if people didn't capture all that information. But again, this will be shared at the end of the presentation. So we're moving now to step 5, which is, let's move to trial. Like all accused persons, the individual is innocent until proven guilty. Every trial is unique and unfolds in many different ways. I mean, we could walk through different scenarios, but it's really difficult to give you a profile or an example just because every youth has with their own complex needs. It depends on their current living situation. It depends on their current contributors about how a trial will unfold and what are some of the practices that will have to be put in place. So we're not going to break that down piece by piece just because I think it's unfair to really go in and dive into a key example. The next step is if you're found not guilty. So on those amazing occurrences where a young person is found not guilty, the youth can be released and all existing conditions are removed on record. I think it's very important to note that having a reconnaissance or conditions removed is one step. But it's very important to note that a youth record is not removed from the actual police file. So, for example, after a specific amount of time, your youth justice court record is not to be used for any purposes that would identify you as an offender. This period depends on the type of offense and disposition. Some of these time periods are as follows. If you are acquitted, your record is kept for 1 month, unless an appeal is filed, which case you may have to wait longer. If the charges are dismissed, withdrawn, or reprimanded, your record is actually kept for 2 months. After an absolute discharge, your record is kept for 1 year from the day you were found guilty. And this list can continue. I think there's about 17 other bullets. But I think the very important case here is that I don't want people to get the message that their record is immediately expunged. It depends, again, on the severity of the case, the disposition factors. If you are found guilty, the youth is usually sentenced right after the trial, or the case may be put over to allow the judge to prepare a sentencing brief. The Youth Justice Court can ask for a pre-sentence report anytime during the proceeding, to which a youth probation office can actually do a really great overview of what are the current support services or presenting issues. Some of the key things that they gather is a personal history, family history. They do interviews with schools. They really look at the existing programs or issues or concerns so that they can guide the youth justice system about what are some best recommendations to address their needs.
All right. So I'm going to speak to a little bit more on the unfit and NCR pieces. So if a person is formal verdict of unfit to stand trial under section 672.31 of the Criminal Code. And then what happens is that case is then transferred to the Ontario Review Board. When we look at not criminally responsible due to mental disorder, this is a little bit different from being unfit. In the case of NCR, the accused may be transferred to the ORB under section 672.34, but an NCR a verdict is given when the person who committed the unlawful act had a mental disorder that made them incapable of understanding the nature and quality of the act, or knowing that it was wrong at the time of the offense, as opposed to at the time of the trial, which is the first one. So given a date for so in terms of those two, the fitness to stand trial and the NCR piece, they can often be confusing, and they are different in the sense that one doesn't affect the other. So in terms of the unfit piece, it really means that if an individual is found, let's say they're found mentally fit to stand trial, they can still later be found to be NCR. So just because you're fit to stand trial doesn't mean that at the time of the crime that you weren't experiencing a mental health crisis, for example. And the opposite is also true. So you can be found unfit to stand trial in the present, but a psychiatric assessment can suggest that at the time of the crime, the individual did know what they were doing and then therefore must be held criminally responsible for it. So when we look at, when we enter that ORB process, the ORB makes a decision, and they often call this a disposition. And the ORB is a group of lawyers, judges, psychiatrists who review each forensic client on a case-by-case basis. So it's a panel of experts, and they make these decisions by determining whether or not the individual poses a significant threat to the safety of the public, as well as the disposition appropriate to that risk. So there's three general outcomes. The first is a detention order where the individual remains in a designated psychiatric hospital. It may also look a little bit different. They might reside in the community under hospital supervision. They may receive a conditional discharge where they're released into the community but have to report back to that designated psychiatric hospital. Or they may be absolutely discharged. So if they have an absolute discharge, it means they no longer pose any significant threat to the safety of the public, and they don't have any of those conditions that I just mentioned. So even though these different dispositions may be in place, individuals can still come into contact with the police. For example, if an individual is in breach of their disposition, a police officer can apprehend high-risk situations as well within the psychiatric facilities themselves. If an offense occurs in that setting, they can also come into contact with the police. And as Tanya mentioned earlier, there are only 6 active youth files, so that's youth under the age of 18 in the ORB currently in Ontario. So for individuals in detention or on these conditional discharge dispositions, the ORB holds an annual hearing to either renew or issue a different disposition depending on how that individual is doing.
And I think, Doreen, this is a good opportunity to go back to that initial question about the unfit in the NCR system. I think that once hearing Doreen's overview of the forensic system and the breakdown of ORB unfit and fit, I think that many Youth Criminal Justice Act processes should be explored and seen whether or not there is room for intervention before entering this complex system. I just realized it's me again. So we're moving into step 6, and I'm conscious of the time, so we're going to try to continue to move this forward so there's room for questions. So sentencing under the Youth Criminal Justice Act, again, it all depends on the charge that's before the court and the current complexity of the file, but all sentences are determined with the length specified to the Youth Justice Court. Youth Justice Court specifies the level of custody as an open or secure. All custody sentences are followed by a mandatory period of community supervision, which means that probation would supervise them after the custodial disposition, and specific criteria for custody sentences, such as court required to consider alternatives. So having that transition from custody to a supervision order is crucial because it really helps the youth transition from a very closed, formalized structure to the open environment. And having probation to support them around those goals and ensure that they're supported back into their community, school system, it's very essential in the process. There are 18 possible options for sentence, which I don't think I need to read through. People can look at them at a later date. But basically, you're always looking at from a scale of less intrusive to most intrusive. So from a less intrusive, you're looking at community-based sentences, such as community orders. For those that are presenting with an Axis 1 or Axis 2 diagnoses, there are options to explore the Intensive Support and Supervision Program, which is ISSP, which also needs to have an attachment of probation order for supervision and care. IRFs would be the most intensive sentence that we currently have under the Youth Criminal Justice Act to support those mental health issues and those that are found guilty of a serious violent offense. Again, there would be a need of a probation order where they're being supervised and supported by a probation officer. Probation is legally mandated. Yet again, it's really supportive to help those youth transition from the custodial to the community. We're going to keep on moving forward, Dorina, so that we can keep on time.
All right, so as Tanya was mentioning, there's several types of youth justice and mental health programs that one can enter at this stage, and that includes the intensive rehabilitative custody and supervision, so the IRCs, and the Intensive Support and Supervision Program, or ISSP, as well as community support teams after the sentence. During the court process and post-sentencing, again, that youth mental health court worker and the programs associated with those type of court workers are also in play. And I already mentioned some of the sort of activities that youth mental health court workers do with youth and their responsibilities there. And at any time, there can be an assessment as well done, and often this happens through telemental health programs. I think that's especially useful in rural and northern areas where there might not be individuals who can perform those assessments, as well as at the SILAPS Youth Center, which is a secure detention and custody service organization, and then Robert Smart, which were mentioned by Tanya before. And we'll just comment briefly around some of the files in those organizations currently.
I'm all about numbers, and so I just wanted to make sure that we demonstrated how a lot of communities are exploring the least intrusive methods for sentencing. So at the recent presentation on impact of Youth Criminal Justice Act over the past decade at the Ontario Canadian Youth Justice Conference, they indicated that for community service orders in the past year they had 65. For the non-residential attendance center, they had 2,526. For the community support program, they had 958. For that ISSB program, they had 130. And for that intensive violent offenders with mental health disorders, IRCs, they had 12 plus since June 2014. And I know that we've been referencing the youth mental health court workers. They've serviced over 2,632 files, as well as they're currently supporting 32 different youth justice courts across Ontario. So definitely great programs providing lots of access.
Great. So now we're going to go into some of the secure treatment criteria.
So I'm conscious of the time. We have about 3 minutes, and I've been given a quick, let's wrap it up in 3 minutes. So for someone who knows me, they know I love to talk, so I am going to do my best to cut this short. So secure treatment, as indicated earlier, is under the Child Family Services Act. It is a very, very intrusive program, which there's very clear criteria, as you can see laid out. For those that wish to look more into it, go under the CFSA under Section 117. The preface of the secure treatment is for those that have mental health disorders, and there's a whole array of many, many, many criteria to which you have to make sure you have in place. You do have to present all this criteria to a superior judge in family court. This is not a direct placement. It is a court-ordered progress to which you need to involve family court. So I would encourage you to look further into that if you want more information. So moving forward, Darina. So for open custody, again, just to have a better understanding about how it looks like, open custody is very lower degree of restraints. So the doors are locked on the outside, but they're not locked on the inside. It's more of a smaller residential type setting, so that they have better access to the community. They do community events. They do their best to try to have that balance between having them in detention, but also exploring community events and making sure they're still in touch with the community. Secure custody is more of a higher degree of restraint. Those are for youth that are presenting a community risk or flight risk or have done an aggravated charge or indictable charge. That's more of a locked from the inside outside. Their movement is very restricted. They are under supervision 24 hours a day, and all programming occurs within the facility.
Great. So I'm just going to finish off our map here. So at this stage and at another point, youth can be in contact with a probation officer. So the probation officer would meet with the youth regularly to develop a plan with them and their parents and really work with them to establish some goals and to help that youth stay out of trouble. And part of their role is also to monitor compliance of some of those court-ordered conditions, and then, of course, return the youth to court if there's any non-compliance. So that covers the sentencing piece, and I'm going to just quickly move along to our last piece of the map. We're in the home stretch along the justice system. So we're talking about reintegration back into the community, and this involves creating a plan to get the youth again either in the community to attend school, obtain employment, and also to access any of the programs that are suitable to addressing their needs. And evidence-based practices actually recommend that reintegration planning begins right when that youth enters into custody. And community mental health service providers will help that person follow the plan and reintegrate into the community. And there's a variety of professionals that can be involved at this stage. Some of you who may be familiar with the Human Services and Justice Coordinating Committees across Ontario, that's some of that they play a bit of that role at the local level where, police services, correctional services, Crown attorneys, and community mental health and addictions professionals come together and really figure out what the best plan is and work with that youth, and their parole officer to make sure they don't re-enter into the justice system. Of course, as you can imagine at this point, there's lots of issues that can arise. Youth can be placed on waiting lists and not connected to programs right away because of the lack of available services. And sometimes they have to remain in the psychiatric facility or where they're being held until adequate community supports can be established. Finally, the community supervision piece, all custodial sentences for youth, as we mentioned already, are followed by a mandatory period of community supervision. And this is, again, all those same roles that I just spoke about of the probation officer and them working with that youth. This final piece here, as we mentioned at the very beginning, is extremely important. It's the support that youth receives from their family and the community, and really access to the social determinants of health are really essential in supporting the reintegration of any individual back into community and preventing recidivism or reoffense. So we're just, as you can see, we've very quickly covered the map. It's very complicated. We've really just scratched the surface in the past hour, and we'd love to take your questions. And I'll just quickly, we do have some references, and you can refer to those when we send you the link when you access this Prezi. And we have our contact information as well if you have further questions.
And I think it's important to note that the criminal justice system is not linear, that at any point through the system you may backtrack, or you could be on probation under supervision and you could breach, and then you're back to step one where you're having initial contact with the police. I think the essential aspect is making sure that you're working collaboratively and sharing information with each other, and to make sure that you're actually addressing the ongoing concerns of the youth.
Okay. Thank you both, Dorina and Tanya, for walking us through the map and through guiding us through Prezi. We wanted to go back to the questions that folks had asked about 20 minutes earlier. We didn't get to all those questions, and I know that Tanya and Dorina wanted to give those questions time as well. So, Dorina, I'll leave it to you to figure out which questions you're going to take.
So I see the one on crisis beds, which is a really quick answer. Crisis beds and safe beds are actually available in the community, not in hospital beds. They're different from hospital beds, and the whole purpose of having a crisis or a safe bed is to ensure that that individual isn't in custody or in a jail setting, but is also not entering the emerge and having to wait, or taking up a hospital bed that may also not be available. So that's how crisis and safe beds work. There are, I believe, designated crisis and safe beds in some areas in Ontario specifically for youth. And I don't know if, Tanya, you're more familiar with what that looks like.
Sorry, I'm reading all these questions, and you know what I love? I know I'm sorry I'm not answering your question, is I love how others are answering each other's questions. And I think that we forgot to mention that you guys, all 139, are such a wealth of experience and information. And I love the fact that even during this conversation, I see others answering others' questions. Love it. Sorry.
That's fine. So let's take it at the top, from the top here. So 5 new youth forensic programs in Ontario. Do you see this changing things? So there's been a shift in the system.
Wow, somebody threw that out there. I'm glad that people shared that information. It is a very quiet new thing where some communities have been very vocal about having those 5 youth forensic beds available in the province. Other communities not so much vocal or launching that information, probably to make sure that there's not a floodgate of referrals. But I think it's an excellent step forward in supporting those youth in the forensic system.
Okay, great. So I'll take over the questions. So do parents participate with workers and clients during the process?
For my approach, I was previously the youth mental health court worker, and I have to say that if people aren't engaging the family in the process, then that's a really big missed opportunity. I think that's because we're dealing with the age range of 12 to 17 less a day. If there is family or supports currently involved in their life, it's very essential to involve them at the very beginning, because I know many programs actually not just look at youth needs, but also the family's needs.
Next question from, do youth and adolescents from up north, so Thunder Bay and area, have access to secure custody facilities in the south? How would a person access these facilities if they're not from that area?
I think Cheryl Hone actually answered that question. In Fort says there's a secure custody youth facility specifically for youth, for Aboriginal youth, to keep them as close to home as possible.
Okay, keep going. Crisis beds and safe beds, are these found through agencies or just in hospitals?
I think Dorina just answered that question.
Yeah.
Okay, keep going. Are you aware of the new funding for youth forensic services in Ontario North Bay?
I think we just covered that big announcement of 5 beds.
Yeah, some of these okay. What types of equity issues arise through the intersection of criminal justice, law enforcement, mental health, and youth issues? Great question.
Equity issues.
Yeah, where's that question? Oh, there it is. Deborah Headley?
Yeah.
Issues arise from the intersection of criminal justice, law enforcement. Wow. Well, I can speak to just some of the areas here in Champlain, because we did a really good comprehensive health equity intake assessment report. It is 52 pages, to which it really speaks to making sure that we have those identifier questions part of the intake process. I know that many agencies do look at that health equity perspective to ensure that if we are dealing with youth that want to self-identify, that we are attaching them to the appropriate pathway of services and supports. But that's just based on best practice.
Thank you. Any advice on how to support clients transitioning in adult mental health services while mandated under a YJ? Good question, because one of the other questions was around why or how did we get, how did we define youth from 0 to 29, and it was really to capture that transitional age piece. So this is a good transitional age question.
Oh, I wish there was a probation officer that was readily available to answer this question, because I think it all depends on where they are in the continuum of the justice system. If they're currently being supported by a probation officer, I know that probation really strives to help with that transitioning role. And there's currently youth in transition positions across the province that actually are dedicated for that role.
People are asking again about the links. So all of the links to this presentation, they'll be up by tomorrow. So please check, if you want to really be certain, please check Monday morning or tomorrow before the end of the day, and you'll find them there. Here's one from Catherine, which is, addiction is often an issue that goes along with mental illness. Is this recognized by mental health agencies when working with youth?
I know that a lot of agencies actually work in partnership with their mental health partners, so if there is addiction concerns, especially with the youth system, they tend to work in partnership. I think that the best thing is to go based on what the youth wishes to pursue. In my experience, many youth are much readily available to talk about their addiction or substance use issues because talking about mental health is more of a stigma, which is a challenge. So sometimes it's easier to address some of the addiction and substance use issues first, and then as you start that relationship building, start addressing some of their mental health concerns. But again, I think it comes back down to the collaboration between both sectors.
Okay.
There were some questions about employment and just, can youth get a job after they are released, from the justice system? And there's some great comments, Catherine Stapley outlining some of that information. I'd just like to say, and it's a bit of a separate issue, but very much related to youth and justice, just around police record checks, and then having some of that, if you have a Mental Health Act apprehension, that it can show up on your police record. And there's an entire report actually on youth and police record checks by the John Howard Society that I encourage you to check out, and we can also give you a link to that when we send out all of our information. But it really looks at how having that record, which is discriminatory in many ways, can really prevent youth from accessing things like placements if they're looking to work with vulnerable populations, and even just volunteer opportunities and things like that.
I think also to look at Heather LeBlanc's question around the confusion around the youth age up to 20 years of age. I just want to clarify that, the 20 years of age is really based on the agency description of how they're servicing the population and youth, and that for our presentation, the Youth Criminal Justice Act is a very dictated age range from 12 to 17 less a day. Anything over 17 less a day, which is 18 and up, is an adult charge. However, based on the agency contracts, they really do dictate how they're going to service the transitioning youth.
Okay, I think we can take one more, maybe two more questions. Dorina or Tanya, did you see any other questions that you thought you could answer? You can point out. Looks like we've got most of them. I think we've got most of them. I'll give a couple seconds for anyone else to maybe throw out one last question and have the final question for the webinar. It's good to see, Tanya was saying that people are taking the time to answer questions for others, and it's also good to see that this webinar has been helpful for folks. We've got a bunch of people typing, just waiting for it to actually come up on the screen. People are typing furiously. Okay.
And I just put up, it says Meredith, but I just put the John Howard Society report there for you.
Great. Okay. So still just good to get appreciation. You can put those things in the evaluation that we'll send out to you in the next day. Looks like there's a bunch of people typing. Jason, Ronnie, George, both are typing. Hopefully we'll get your question in before.
So one interesting question I just caught is, do we have statistics on how many youth have navigated the two system in the past year, and what are the type of charges? So do we have, I don't know if you've got those, or just if you can speak to that from experience, Tanya.
I have the breakdown of charges, but I believe that that's an internal document. I think that the stats that I kind of spoke to about how extrajudicial sanctions and measures and community-based programs are actually being accessed more really lends to the shift where there's more summary offenses, less indictable offenses, and if there is indictable offenses, they're the ones that are actually, in custody or more intrusive environments. I think that the housing of young offenders with summary offenses is less and less. It's more of really looking to the community for their support to ensure that those youth are integrated back. So I can't really share the breakdown of statistical information, but that could be something that could be explored at a later date, maybe through MCYS.
Okay, great. That was a good last question. Thank you so much for questions. There were a lot of questions today, great questions. This concludes the third webinar in the series. Next week, there won't be a break, so next week we have our fourth webinar, which is really focusing on bridging social media supports and mental health supports. So there's should be pretty interesting. We're having our techie friends from Mind Your Mind join us for this one, so you'll see some interesting things on the screen. And this topic is actually a new topic that people are starting to explore within the sector. So looking forward to associated with that website, so if you have trouble finding things, send an email. And until then, have a great week. Take care.